Have you ever wondered how a mango grown only in Maharashtra, a folk song, and a semiconductor chip can all be protected under the same legal system just through different laws? In today's session, we'll go through the major Indian legislations for the protection of various types of intellectual properties, covering patents, trademarks, copyright, designs, geographical indications, plant varieties and farmers' rights, semiconductor integrated circuits layout design, and trade secrets. By the end of this lecture, you'll clearly understand the specific acts, their terms of protection, and the recent amendments, all of which are extremely important from an exam point of view. Let's begin by understanding Introduction to IPR in India. The first point is definition, legal rights governing the use of creations of the mind. The next point is objective, to foster innovation by providing exclusive rights to creators. Another point is global alignment. Indian laws are compliant with the TRIPS Agreement, WTO. And finally, nodal agency, Department for Promotion of Industry and Internal Trade, DPIIT, Ministry of Commerce and Industry. Remember this because it is frequently asked in examinations. DPIIT as the nodal agency is a very common one-mark question. Moving on to overview of IP types in India. India provides statutory protection for patents, 1970, trademarks, 1999, copyrights, 1957, industrial designs, 2000, geographical indications, GI, 1999, plant varieties and farmers' rights, 2001, semiconductor integrated circuits layout design, 2000, trade secrets, common law protection. Think about this for a moment. This list of 8 acts with their years is the backbone of today's entire lecture, so keep it in mind because we're going to go through each one in detail. Let's continue with 1. The Patents Act 1970. The Patents Act 1970 remains the foundational legislation governing patent rights in India. Over the decades, it has undergone significant amendments. Protection of new and useful inventions, products, and processes. Let's look at the criteria for patentability. The first criterion is novelty, must be new worldwide. The next criterion is inventive step, must be non-obvious to a person skilled in the art. And the third criterion is industrial application, must be capable of being made or used in an industry. Term of protection, 20 years from the date of filing. Now, non-patentable subject matter. Section 3 and 4 excludes things like frivolous inventions, ideas lacking purpose, credibility, discovery of living things, mathematical or business methods or computer programs per se, atomic energy. This is one of the most important concepts in this chapter, since novelty, inventive step, and industrial application together form the 3-part test for patentability that examiners love to ask about. Building on that idea, let's discuss patents, key provisions, and term. Let's look at the amendments. 1999, mailbox system to store product patent applications for drugs and chemicals. 2002 increased the patent term to a uniform 20 years for all inventions, which was previously only 7 or 14 years. 2005, introduction of product patents, where the actual products can also be patented and not only the method. Also, prevented patents to products with minor changes as the previous one. 2024-2025, period for requests for examination is reduced to 31 months from 48 months. Certificate of inventorship has been introduced for academic purpose. Keep this point in mind because we'll use it again later. This amendment timeline, especially 1999, 2002, and 2005, is one of the most frequently tested areas of patent law. The next concept we'll discuss is 2. The Trademarks Act 1999. Purpose: to protect brand identity and prevent consumer confusion. Definition: a mark capable of being represented graphically and distinguishing goods or services. Let's look at refusal of registration. Absolute grounds, Section 9 and 11, marks that are not distinctive, describing quality, quantity, etc., or that hurts religious beliefs. Also, identical or similar to an existing trademark. Now, what can be a trademark? Words, logos, slogans, shape of goods, packaging, color combinations, and sound marks. Let's continue with trademarks, registration and enforcement. Term of protection, 10 years, renewable indefinitely every 10 years. Rights granted, exclusive use of the mark for specified classes of goods or services. Let's look at the amendments. 2010, single application for protection in 100 countries. Opposition period fixed at 4 months. To complete the registration process within 18 months. Easier selling of trademark. 2017, form reduction to 8 from 75, well-known trademarks. 2024 to 2025, protection for digital assets. Now, legal remedies. Infringement for registered trademarks, passing off, common law remedy for unregistered marks. Remember this because it is frequently asked in examinations, the difference between infringement and passing off, and when to use each symbol are classic exam questions. One more important concept is 3. The Copyright Act 1957. Scope protects original expression of ideas, not the ideas themselves. Let's look at the covered works. Literary, books, computer programs or software. Artistic, paintings, photographs, architectural drawings. Musical and dramatic, scores, plays, choreography. Cinematograph films and sound recordings. Moving further, let's discuss copyright, terms, and digital rights. Let's look at the term of protection. Literary or artistic, lifetime of author plus 60 years. Films or recordings, 60 years from publication. Fair use doctrine allows limited use of copyrighted material without permission for research, criticism, or news reporting. Now, the amendments. 1994, software protection by including computer programs under literary works. 1999, introduced rental rights for computer programs and films. 2012, right to prevent digital piracy, right to receive royalties for lyricists and composers, etc. This is one of the most important concepts in this chapter. Students often confuse the copyright term for literary works versus films. So remember, it's lifetime plus 60 years for literary works, but a flat 60 years from publication for films and recordings. This brings us to 4, the Designs Act 2000. Focus protects the aesthetic appearance only. Let's look at the requirements. Must be new or original, must be applied to an article by an industrial process, visible to the eye, appeals to the sense of sight. Exclusion, functional features are covered by patents, not designs. Now, the amendments. 2021, recognizing startups as a category of applicants, reduced fees, documentation via email and mobile phones. 2024, preferring only online application filing and examination time was reduced to 1 to 2 months. Term, 10 years, extendable by 5 years, maximum 15 years. Think about this for a moment. The key distinction here is that designs protect only how something looks, while patents protect how something functions. This brings us to 5, the Geographical Indications Act, 1999. Definition: it is a sign used on products that have a specific geographical origin and possess qualities or reputation due to that origin. Examples: Alfonso mango, Maharashtra; Nagpur orange; Mysore sandal soap. Nature of right: a collective right, belongs to the producers of the region. Let's look at the amendments. 2020, ease towards documentation towards registering and being an authorized user of a GI tag. 2024, employing adjudicating officers to handle complaints regarding the misuse of GI tags. 2025, reduction in various fees like application fee from 5,000 rupees to 1,000 rupees, renewal fee from 3,000 rupees to 500 rupees. Term, 10 years, renewable every 10 years. Remember this because it is frequently asked in examinations. The examples like Alfonso mango and Mysore sandal soap are commonly used in questions asking you to identify GI tagged products. Let's continue with 6. Protection of Plant Varieties and Farmers' Rights, 2001. Unique feature: India's sui generis system that recognizes both breeders and farmers. Let's look at protection for new varieties, existing varieties, farmers' varieties. Now, the amendments. 2021, Section 34 reinforced that if a breeder's registration was obtained based on incorrect information, or if it harms the public interest, it can be revoked. 2024 to 2025, 14 new species were added, including curryleaf, lemongrass, ashwagandha, etc. Farmers' rights. Farmers can save, use, sow, resow, exchange, or share their farm produce, including seeds of a protected variety. Since many of you are from agricultural and food technology backgrounds, this act is especially relevant to your field, so pay close attention here. Let's continue with 6. Protection of Plant Varieties and Farmers' Rights Act 2001. Looking now at the key rights. Section 39. It restricts the farmers to sell the branded seed of a variety protected under the Act. It also states that a farmer cannot be sued for violating the Act upon proving they are unaware about the law. Section 30. It allows the researcher to use the registered variety to conduct an experiment or using it as an initial source for creating something new. Section 24. The Act allows the breeders to produce, sell, market, distribute, import, or export the registered variety for a fixed term, 15 years for annual crops, 18 years for trees or vines. Term, 15 to 18 years depending on the type of plant. This is one of the most important concepts in this chapter. Sections 39, 30, and 24 are frequently asked individually, so make sure you can match each section number to its specific right. One more important concept is 7. Semiconductor Integrated Circuits Layout Design Act, 2000. Purpose: to protect the topography or layout of transistors and other circuitry elements on an integrated circuit, chip. Criteria: must be original, distinctive, and not previously exploited commercially. Recent changes in 2024 to 2025 focuses on digitizing the registration, examination, and hearings. Term of protection: 10 years from the date of filing or first commercial use. Let's continue with 8. Trade secrets and confidential information. Status in India: no specific Trade Secret Act. Let's look at the method of protection. The Contract Act, through non-disclosure agreements, NDAs. Common law: action for breach of confidence. Key requirement: the information must have commercial value and be subject to reasonable steps to keep it secret. Notice how this connects with the previous topic. Unlike patents or copyright, trade secrets in India don't have a dedicated act and instead rely on contract law and common law remedies. Finally, let's discuss conclusion and future outlook. Summary: India has a robust, TRIPS-compliant legal framework. Let's look at recent trends. Digitalization of the IP filing process, e-filing. Fast-tracking of patent examinations for startups and women innovators. Increased focus on IP enforcement and awareness. Key takeaway: IP protection is the backbone of the Make in India and Startup India initiatives. This slide lists the references used for this presentation, including the official India Code website, the e-Gazette, and the Copyright Office of India, for anyone who wishes to explore the original acts in more detail. Thank you. And that concludes today's lecture. If you found this lecture helpful, please like the video, subscribe to our channel, and share it with your friends. If you have any questions, feel free to leave them in the comments section. Thank you for watching, and I'll see you in the next lecture.